Hello, everyone. My name is Steve Blake, and today I'm going to be giving a webinar presentation on premises liability for commercial properties. The webinar will talk about what premises liability is, what duties the landlord or owner of the property has in a premises liability dispute, how liability is determined in a premises liability case, potential insurance coverage that a owner of a property could have if faced with a premises liability claim, how premises liability is determined by a court, and then common defenses that a landowner or landlord could have to a premises liability claim. So first off, a commercial property owner in California or a tenant of commercial property has a duty to exercise ordinary care in the management and maintenance of the premises in order to avoid exposing persons to an unreasonable risk of injury. In the event a person is injured on a commercial property and it's determined that the injury was the result of the owner and or the tenant's lack of ordinary care of the property, then the owner or the tenant could be liable for premises liability and be ordered to pay the injured party damages. And a concept that's important to understand is a premises liability action. It's not based on just holding the owner of the property or the landlord responsible for the conduct of others in all circumstances. That's not what premises liability is. What it is the failure of the owner or the tenant to act reasonably under the circumstances when they may have reason to believe that the probability of injury could occur. And therefore the owner or the tenant has a duty to take steps to prevent that injury and or warn of the dangerous condition so that people won't injure themselves on the property. In the event a landowner is sued for premises liability, oftentimes these types of claims will be covered by an insurance policy for the property that the owner has. However, those policies typically have a high deductible that could be $50,000. And also, if the insurance coverage is insufficient, let's say it's a $1 million policy, and the damages to the injured party exceed that, it could expose the owner to a substantial monetary loss. So just because insurance exists doesn't mean it will adequately cover the claim. So therefore, it's important for commercial property owners to be proactive in ensuring that their premises are free of any defects that could cause foreseeable injury. And in terms of what is a premises liability claim, oftentimes you hear about trips and falls where somebody goes onto a commercial property and they trip on a broken sidewalk or a curb or something like that. And that's, kind of the one that everybody thinks of. But there's also premises liability for things like if there's asbestos in the property and the owner knows about it and somebody comes in and gets sick because of ingesting asbestos. Same thing with mold. Also, something is inadequate security. Let's say that there's a commercial property that's known for having some criminal activity and the landowner does not hire sufficient security to police the property, and somebody gets mugged or beaten at the property. They could potentially say that the security was inadequate, which is the landowner's fault, and it could open them up to a premises liability claim. Also, things like dog bites or a defective elevator. People get injured in elevators more than you'd think. And if there's some reason to believe that the owner knew that this elevator was defective and they weren't maintaining it properly, that could potentially open up a landowner to a premises liability claim. So there's a wide variety of issues that can rise to the level of a premises liability claim. If the injured party does file a premises liability claim against a landowner, it's essentially a form of negligence. And what that means is if the injured party goes to court, they have to prove certain elements to hold the landowner liable. And the first element is to show that the defendant, which is the property owner, they owned, leased, occupied, or controlled the property. So it could be a tenant, it could be just the building owner. Then they have to show that the defendant was negligent in its use or maintenance of the property. And this is usually a pretty intensive factual inquiry during a trial. For example, if there is like a broken sidewalk that somebody trips and falls on, the injured party is going to want to show that the landowner was aware of that, that they, potentially somebody else had tripped and fall on it earlier, and the landlord did not take sufficient steps to fix that, which caused this other party to be injured. Thirdly, the plaintiff has to show that they were actually injured, which typically comes in the form of medical records or testimony from doctors. And then the defendant also has to show that, but for the owner of the property's negligence, they would not have been harmed. In the event that the injured party is able to prove those elements, they can claim damages against the property owner or the tenant. And typically in these types of cases, the damages that will be at issue are the past and future medical expenses of the injured party, potentially lost wages if they've had to miss work because of this injury. Let's say somebody, is in the hospital for several months and they can't go to work. And potentially, if the injury is bad enough, it could prevent them from working to their capacity in the future, which they could make a claim for those future lost wages. And then there's things like pain and suffering, also court costs, filing of the lawsuit, other costs that they're incurring along throughout the litigation, typically not attorney's fees, but court costs would be something that they could ask for. Also expert witness fees. In a lot of these types of cases, the plaintiff is trying to show that the defendant was negligent and the defendant is a property owner or a tenant. So they may need an expert witness to come in and say, the standard of care in the industry is to fix, for example, these broken sidewalks in a timely manner. Here's how much it would cost. Here's the timeline that they could do it. And the expert witness could opine that, based on what they've seen from this landowner, they don't believe that they appropriately handled fixing this issue. And then finally, punitive damages is something that a plaintiff could be entitled to if they can show that the defendant's conduct was reckless, malicious, or rose to some level of extreme indifference toward the plaintiff. And punitive damages are very hard to obtain in California, just as a general rule. But if the injured party was able to discover some evidence that, there's been 10 other people that have tripped and fell on this broken sidewalk, the landowner knew about it and they purposely didn't do anything. They didn't care. The cost to repair it was nominal, $1,000, and they just didn't care. So if there's certain factual allegations that can rise to the level that show that the defendant really was just reckless with this issue, it could entitle them to punitive damages. And the amount of punitive damages is something that's in the discretion of the judge or the jury. So it's really hard to say what those could be, but if the facts were bad enough, it could be substantial. Typically, with a premises liability case, it's a form of negligence, and it's typically a 2-year statute of limitations from the date of the injury, meaning that whatever date the injured party was allegedly injured on, they've got approximately 2 years to file their case in court. And if they don't file it within that 2-year period, they could be barred from filing it later. So if ever, as a landowner, you do get a claim made against you or a lawsuit filed, that's one of the first things to check is when was the injury, when did it happen, and when was this lawsuit filed? Some of the defenses that are commonly raised to premises liability cases on behalf of a landowner or a tenant is that the owner or the tenant did not have possession or control of the property where the injury occurred. And the easiest way to describe this is if we use that broken sidewalk. And if you think about it, like the tenant, if you're looking at like a shopping center, the tenant may have a retail space and there's a sidewalk out in front of the space. And it could be a dispute between the owner of the building and the tenant about who actually controls that sidewalk, who's responsible for maintaining it. And the tenant may say, that's not my responsibility, even though, I've been sued for premises liability. Me as the tenant, we don't have control over that sidewalk. That's the landowner's responsibility. Or, on the other side, maybe it's something where, that tenant does have control of that sidewalk. Maybe it's a restaurant and they have some patio seating or something like that. So another important thing to look at when you're faced with a premises liability claim is exactly where did this injury happen? And what do the leases at the property say about who has control of that specific piece of the property? Another defense to premises liability claim is that the owner or tenant did not have knowledge of the dangerous condition, and therefore they did not owe a duty to the injured plaintiff to warn him or her about the hazard. And, if you take the broken sidewalk, let's say that that's been there for a while and the landlord, puts up a little sign there, trip hazard, be careful. The landlord has knowledge of that. They're trying to do something to warn people to, be on the lookout, try not to step here. But let's say it's something else where, there's a broken window or a, piece of the ceiling falls out of a premises and hits somebody in the head. Things that happen like that, it's never happened before. The landowner had no knowledge that this was going to happen. So a defense could be, me as the landowner, I didn't have a duty to say anything about this broken window or, the ceiling tile that fell down and hit somebody in the head because we had no idea that this was a problem. It's never happened before. Therefore, we didn't owe a duty to this plaintiff. So that could be a possible defense to get out of the case. And then another defense could be that, the plaintiff was not injured or that this injury was a pre-existing condition. For example, maybe it's not disputed that, yes, the sidewalk was broken and yes, this person tripped on it and fell, but they weren't injured. And, we've examined their doctors and they haven't found any, permanent injury or anything like that. Or, we looked at the injured person's medical records and it shows that, they've had a broken knee for years. And this is an injury that did not occur because of the trip at the premises. It's something that they had already had. So those are some of the common defenses. At the end of the day, premises liability claims are complex and they can have substantial adverse consequences to the landowner or the tenant, especially, if there's something that could rise to the level of punitive damages. This could be a business ending claim. So therefore, it's very important to consult with an attorney in the event you are dealing with a premises liability claim. It's important to understand, what happened, when it happened, who saw it, are there any photographs, what's the history of this, defect at the property, and make sure that you're talking to your team and understanding, the whole sequence of events, because that'll help when it comes time to evaluate, what the merits are of the premises liability claim. The attorneys here at our firm are very experienced in litigating these types of claims. So we're happy to talk to you if you're ever faced with this situation. I want to thank you for your time, and our contact information is on this slide. So please feel free to contact us if you ever have any questions. Thank you very much. Have a nice day.